Well, thank you for joining. We are kicking off tonight's event, the Fight for Fair Courts, How to Keep Politics Off Our Bench. I'm really grateful for our co-sponsors today, the ACLU of Ohio, the Black Lawyers Association of Cincinnati, Common Cause Ohio, and the Ohio Fair Courts Alliance for helping to put together the event and to promote it and get lots of lovely folks here in attendance tonight. We're going to go till about 8 o'clock or so. We're going to have plenty of time for folks to weigh in and ask questions and have comments. So we're excited. Thank you. Next slide. My name is Camille Wimbish. I am the Election Administration Director for Ohio Voice. I'm a part of the Ohio Fair Courts Alliance, and I am joined by some brilliant colleagues of mine. Mia Lewis, did you want to say hi, Mia?
Hello, folks. I'm hiding behind here.
Mia's going to be doing the yeoman's work of advancing all the slides and keeping us on target. And we also have Jessica Dickinson. Jessica, do you want to say something?
Hi, everyone. I'm the outreach manager for the Ohio Fair Courts Alliance. It's so nice to see all of you. Thank you for joining us.
And so we are an organization, we've been around since around 2015. These are sort of our founding organizations. Essentially, we got together to sort of brainstorm how we might think about reforming some of our courts. And we very quickly realized after doing some listening sessions and tours around the state that Ohioans were really hungry for some basic education about the importance of judges and what the role of courts are. Next slide. So our vision is sort of a court system that exemplifies and protects equity, fairness, and justice for all. I think certainly with all of the events that have happened in the last year or so, you know, I think this vision is really sort of center in my mind and our hearts, and I'm sure that's what is also drawing you to this work as well. Go ahead, next slide. So some of the goals for us, for our next slide. Our alliance is really to, again, raise public awareness of the importance of our courts and the need for impartial justice. We're looking to build stronger coalitions across Ohio. We know there are things that we can fix to make our courts even stronger, and but we're going to need to do it together. We're going to have to rally together. And we're particularly interested in looking at ways to pass stronger rules to limit the influence of money and special interests. You know, of course, some of our mid-range and longer range goals, you know, we have a platform of looking to end the death penalty and, you know, getting rid of cash bail. Certainly, we would love to see racism sort of wiped out of the justice system, but we know that's going to take a lot of hard work. And so we're excited to be working together. Next slide. So tonight we have some really fantastic, wonderful panelists here to share their wisdom and their experiences. We're pleased to welcome Paul Pfeifer. He's the executive director of the Ohio Judicial Conference. That represents the interests of Ohio's 723 judges at all levels of the state court system. He's also a former Ohio Supreme Court justice. From 1993 to 2017, he served on the bench and he retired due to the constitutional age restrictions for judges. But prior to being on the bench, he also served on both houses of the Ohio General Assembly, including 1 term in the House of Representatives, 4 terms in the Senate. He's held a variety of leadership posts, including serving as the chairman of the Senate Judiciary Committee for 10 years. So thank you, Justice Pfeifer, for joining us. And next, we've got Fanon A. Rucker. He's a retired Hamilton County Municipal Court judge. He's also been a former Cincinnati prosecutor and civil rights attorney. He's served as an adjunct professor at the University of Cincinnati for several years, teaching a class on law history, and has currently serves as an Ohio bar examiner. As a judge, he presided over more than 200,000 cases. I can't even wrap my mind around all of that. 200,000 cases, including several hundred civil and criminal bench jury trials. So welcome, Judge Rucker. Next, we have Patrick Berry. Patrick is a fellow and counsel at the Brennan Center for Justice Democracy Program. He focuses on voting rights restoration and promoting fair, diverse, and impartial courts. He recently received his BA from the University of Central Florida and his JD from the University of Pennsylvania Law School, where he participated in the legislative clinic and was an executive editor for the Journal of Law and Public Affairs. Thank you, Patrick. And then last but not least, we've got Melekte Melaku. She is the organizing strategist at the ACLU of Ohio, whose work focuses on criminal legal reform. She's a graduate of the Case Western Reserve in Cleveland and is an alumna of the Obama for America Fellowship Program. She has extensive experience on issues related to pretrial reform, juvenile justice, LGBTQ protections, and educational equity. So thank you all for joining us tonight. We're excited to hear from you. Let's go on to the next slide. So what I have in store for tonight is sort of quickly laying out a few sort of basics around Ohio judicial elections. Then we're going to have each panelist give remarks for around 5 or 7 minutes or so. We'll have lots of discussion, questions, and then we'll leave you with some information about ways you can get further involved. Okay. Next slide. All right, here's some fast facts for folks. I know lots of you are sort of veterans to this work, but for making sure everyone has a basic understanding of what we're talking about here. Of course, Ohio elects our judges. In the primary, we have a very sort of unique system in that judges that appear on the ballot have a partisan label when they win the primary. So they'll be identified as a Democrat or a Republican. I suppose they could be independents as well, but they typically run according to one of those parties. Then there's the general election that comes around, and those are considered nonpartisan races. So the winners of the primary election will face off, but there will not be party labels that appear on the ballot. And then this is sort of a little link here. There's like a pros and cons of some folks who weighed in on whether party labels are helpful or not. But of course, we'll be getting into that a little deeper tonight. Next slide. Okay, so this is a slide that talks about voter participation. So of course, getting everyone out to vote is something that's near and dear to our hearts. Certainly folks who turn out to vote in the general election, if they're going to vote for president or governor, many of those folks will then decide, I'm not so sure, I'm not going to vote on candidates for judge. And that has sort of course, been a concern, but in some years, it can be up to 25, 26% of voters deciding that they don't want to vote for Supreme Court judge. And then some years it's been as low as 14%. So that's kind of where we are in terms of judicial ballot roll off, and something to keep in mind for what we can do to try to get those numbers up so that people are having their voice heard and weighing in on these important races. Next slide. So there was a 2014 election survey that sort of gauged why is it that people might skip voting for judge. And one of the biggest reasons that is cited is that 63% said they just didn't know enough about the candidates. 3 and 5 said they just don't have enough good information. They're not really sure where to get the information. 70% said they would love to know more about their professional background. 45% said a nonpartisan voter guide would be more helpful. And interestingly enough, only 19% said a party label would be more helpful in making their choice. All right, next slide. All right, so sort of why are we here today? One of the reasons that sort of kicked off this idea for doing this talk is that there is a bill that's being fast-tracked by lawmakers that's sort of going to inject more partisan politics into these high-profile judicial races in the state. Senate Bill 80 has been advanced on the Senate. There's also an identical piece of legislation in the House, House Bill 149. It would require candidates for Ohio's appellate courts and the Supreme Court to list their party affiliation on the general election ballot. And I think it is really worthwhile noting sort of the political landscape and understanding some of what's been happening. In recent years, Democratic candidates have made gains on the highest court. shifting the balance from a 7-0 majority of the Supreme Court to 4-3. So it's a much more balanced and divided, sort of more politically balanced at this moment. And so there is some, partisan, I think, calculations in terms of why lawmakers might be wanting to put partisan labels on those races now. So this politicization of our courts, it's definitely concerning for us at the Fair Courts Alliance. I think it's also a sign and symptom of what's happening around the country. And it's part of the reason why we're here to talk to you tonight. And that's what I'm going to open the floor up to hearing from our panelists. I think this is a really good segue to open it up. We're going to hear first from Patrick Berry.
Thanks so much, Camille, and thanks again for having me here today. I'll just give it a second so we can get my slides up. Great. So again, my name is Patrick Berry, and I'm an attorney at the Brennan Center for Justice. And this evening, I'm going to talk about legislative efforts to weaken or politicize state courts. So as you'll be hearing more about this evening, state courts are actually really, 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 really important. And recognizing this influence, state legislators and governors across the country have sought to obtain more power or influence over their state's courts over the years. And we've been tracking these efforts for years, and what we've seen has been a really troubling trend of partisan power grabs targeting the courts. And these efforts are simply very dangerous because courts are meant to play a very particular role in our democracy and system of checks and balances. And they simply can't play that role when they are brought into the partisan muck by elected officials. Many of the bills that we've seen seek to change how judges are selected for partisan advantage. Others would restrict the cases courts can hear, and others would exert other political, financial, or other pressures to change the outcome of future cases. Often these bills are introduced in response to specific court decisions that the legislature doesn't like. In Oklahoma, for example, bills followed high-profile decisions related to the death penalty, abortion, and religion that ran counter to the state's conservative politics. We've also often seen these bills in states where there's a closely divided court, or states where there's been a transition in power. So in North Carolina, for example, proposals to gerrymander judicial districts, to cut judicial terms from 8 years to 2, and to give the legislature more power to pick judges, followed Republicans' loss of the governor's mansion, as well as a majority on the state Supreme Court in 2016. Next slide, please. These legislative assaults continued last year, even with COVID-19 raging throughout the country. In 2020, lawmakers in at least 17 states considered at least 42 bills that would have made their courts less independent and more political. Of those bills, 11 would have changed how judges are selected for partisan advantage, including bills that would have weakened or eliminated judicial nominating commissions, an important tool that has been used for years to keep politics out of judicial selection. 15 bills would have put pressure or restrictions on judicial decision-making, including bills in Alabama and Colorado that would have limited judges' discretion over cases related to the death penalty or religious freedom disputes, respectively. Legislators in 6 states also considered bills that would have allowed states to refuse to enforce court decisions or laws the legislature disagreed with, including a bill in Iowa that would have allowed the legislature to decide the constitutionality of laws they themselves wrote. Other bills would have given politicians more control over court rules or resources, increased the likelihood of judges being punished for unpopular decisions, or led to more guns in courthouses, even if courts themselves wanted to prohibit weapons. And while only one of those measures went into effect, our analysis for 2021, which is still underway, has found that bills targeting state courts are particularly widespread this year, including at least 5 that have been signed into law so far. And while many of the trends that we've documented in the past have carried over into 2021, a new troubling trend that we've seen this year are bills targeting courts or individual judges for decisions they made around the 2020 election. Bills in 6 states would not only prohibit state courts from modifying or suspending state election laws, as was often the case last year because of the pandemic, but they would also prohibit courts from striking down restrictive voting laws that are unconstitutional. 2 states, Minnesota and Tennessee, have also seen partisan efforts to remove sitting judges over decisions they issued last year to ensure that all eligible voters had access to the ballot despite the pandemic. Unfortunately, state legislatures aren't the only ones attacking state courts. Governors are as well. In Oklahoma, for example, a former governor responded to a state Supreme Court decision halting executions by threatening to disregard the court's decision. And even more recently, in Alaska, the state's governor vetoed over $300,000 from the state court's budget in retaliation for a state Supreme Court decision blocking restrictions on Medicaid funding for abortion. With state courts already under attack, it's critically important to recognize that they're poised to get even more attention in the coming years. We saw this last year with the election, with many more pro-voter lawsuits being filed in state courts as opposed to federal courts, given the federal judiciary's reluctance to protect voting rights during the pandemic. And we'll certainly see it this year in the realm of redistricting because of the Supreme Court's decision that federal courts can't stop partisan gerrymandering. So needless to say, the stakes are very high. And this is not just in terms of our democracy, but many other important fights to come. And if our tracking over the years has taught us anything, it's that we can count on state legislators and their governors to be paying attention to state courts, even if others aren't. And with that, I will turn it over to Justice Pfeifer. Thanks again for having me. I look forward to hearing your questions during the Q&A.
Okay, well, that was, thank you, Patrick. That was scary. I didn't know much or most of that. Has me feeling better about Ohio and the Ohio General Assembly, because the bill that we're concerned with right now, or the House and the Senate bills, are fairly simple and straightforward. It proposes to require partisan identification of Supreme Court candidates and courts of appeals candidates only. And some have questioned, well, if you think that's such a hot idea, why aren't you taking it on down to the trial courts? Even some trial judges have suggested that they're not asking for it. They're using that as a criticism. So at this point, we have not seen anything that tries to cut budgets or change terms of elections or any of those other things. I think there would be a resistance to that in Ohio. So I'm gonna cut to the chase first and give you my take on the why. And the why is because they can. It's just a raw political decision on the part of Republicans, and I think it's going to pass. It's already passed the Senate with these, all Republican members of the Senate supporting it, are all but one. And in the House, there might be a chance. I think Speaker Cupp, a former Court of Appeals judge, former Supreme Court justice, I have not had a conversation with him. I've heard that he's cool toward the idea. That wouldn't surprise me. I think he probably thinks it's a very bad idea, but he won the speakership by a thin reed. And so when you're in that position, there are only so many causes that you can lay down on the tracks for. And I would be surprised if this is a cause that he's willing to lay down on the tracks for. So I think it's going to happen. I think it is a miscalculation on the part of Republicans. Clearly, you've seen some discussion in the press that they are feeling like they shouldn't have lost 2 seats 2 years ago. One of those races, Justice Donnelly won by 1 million votes. I can't imagine how a partisan identification would have changed that outcome. The race that they seem to feel stung about the most is Justice Brunner, who I see is on this, winning and defeating the incumbent Justice Judy French. You had a race between two highly qualified women from Franklin County. Justice Brunner happened to have held statewide office before, and she won by 500,000 votes. So again, I think they're whistling in the graveyard when they think that party identification would make a difference. I think what they're really focused on, I think that's what got this started. What they're really focused on is the next Supreme Court election. They've dragged the Court of Appeals along for cover to make it seem like they care about that as well. The result with respect to courts of appeals, I think, is going to be to make the Court of Appeals races non-competitive in several appellate districts, the 3rd in Northwest Ohio, the 12th in Southwest Ohio, the 4th in Southeast Ohio. It will be exceedingly difficult for a Democrat to win in those appellate districts if you have party identification. And I think that's unhealthy. In the 1st, which is Cincinnati, in the 10th, which is Columbus and Franklin County, both of those communities have trended, moved big time in favor of the Democrats. And then, of course, the 8th in Cleveland, it will be exceedingly difficult for any Republican appellate judge to have a chance to move up to the Court of Appeals. And I think that's unhealthy. We need competitive races. I think the Republicans who are pushing this are going to find that when the dust settles, they're likely to have less Republican courts of appeals judges around the state than they presently have, and that they will have locked that in perpetuity. So that's the bottom line of what they're focused on. They're really focused on the upcoming Supreme Court race. Justice Fisher won narrowly. He's up for re-election. And that's, I think that's what this is really all aimed at in just a practical political sense. Now, I'll take the remainder of my time to talk about why it's a bad idea. In my new life as executive director of the Judicial Conference, one of the most enjoyable things I do is just get around at breakfast and at lunch and sit at different tables and just mingle in the conversations and listen to the judges. And this is where they're exchanging what's on their minds, sharing problems, sharing jokes, you name it. I never hear them talk about partisan politics, never. I am frequently surprised to learn what the party affiliation is of judges that are our members. I don't know. I don't care. It doesn't matter. It doesn't matter to them. Our whole system is built on impartiality and the importance of public perception of impartiality of judges. And so it starts when someone decides they want to take a swing at running for judicial office. And so it doesn't matter if you were a legislator, if you were a prosecutor, you were a public defender, if you had held partisan office, if you had been a campaign activist on one side or the other, you start out with going to school before you ever start with an instruction on the rules of the road, all the things that you cannot say. You can't go to a Republican or Democrat function and you know, if you're lucky, you get a couple of minutes to introduce yourself and tell them why you want to be a judge. But you can't stand there and say, you know, Joe Smith is running for county commissioner. He was my law partner. I love the guy. He'll make a great county commissioner. You can't do that. You can't wade into any race. You know how high the passions were in the presidential race. Judges and judicial candidates can't say a peep about that. You know, they can say their personal friends, but they can't make public statements. And so that's ingrained from the start. And, you know, I was in partisan politics first, ran statewide 3 times in partisan political races. Statewide judicial races and any judicial race are just totally different. And that's ingrained in every person who chooses to say,
Judge
3
Pfeifer,
judges
there
are
we go.
proud of that. Yes.
We lost you for a second, but you're back.
Okay. I can tell you that judges are very proud of protecting the reputation for impartiality. And while if this passes in Ohio, it's not the end of the world, but it's a dent in the ever so fragile effort that we have to perpetuate the public impression that people who wear the robes, once they put on that robe, are going to be fair and impartial in every respect. And certainly their political party affiliation makes no difference. And I will close by saying that I think in listening to the legislature, they don't understand. They don't understand at all. They kept saying, well, this will mean more people vote. Well, if the only reason more people vote is because they see an R or a D and that prompts them when they otherwise were not going to vote because they concluded, I don't know anything or don't know enough about these 2 choices that I face, I think it's a good thing when they are wise enough to say, I don't know enough. I'm not going to cast a vote. But to think that you look at it and you see it's an R or a D, and that tells you something about what kind of a judge that person's going to be, is just totally misguided. And I think that's the mistake that legislators are making. They actually believe that makes a difference in terms of what kind of a judge, how fair somebody's going to be, how wise they're going to be, how informed they're going to be. It makes no difference whatsoever. There's such a range of people who call themselves Democrats and such a range of people who call themselves Republican that knowing that someone's a Republican or a Democrat just tells you absolutely nothing when it comes to the suitability to be a judge. That's it for me.
Thank you, Justice Pfeifer. Judge Rucker, you want to give your remarks?
Sure. Thank you, Camille. And thank you all for allowing me to be here with you this evening. I appreciate anytime I'm in the same room or in the same space with Justice Pfeifer. We work closely at the Judges Association. And when I retired, I reference his name quite often in some of my pursuits. So I do appreciate his wisdom and his practical information about this process. From my perspective, let me just offer that I was a trial judge here in Hamilton County out of Cincinnati from 2007 until 2019. And in that, I had to run for election and re-election on several, 2007, 2011, 2017, I believe. Also ran statewide for Supreme Court in 2012 in a party primary, and for Court of Appeals here in 2014. And each of those races, I was endorsed by a political party. Although the individuals who were going to the ballot to mark my name or to mark my opponent's name in some instances didn't see that I was supported by a party. But what they did see were sample ballots. What they did see sometimes were coordinated campaigns of the other individuals who were running on the same ticket for other offices. And they said, these are the people who party-wise we support. And the same for my opponents who were endorsed, because there has never, at least in Hamilton County, been someone elected to a judicial seat who was not endorsed by, or who is running endorsed by a party, even though those labels don't appear on the ballot. But here's the problem with it. First of all, what we do have to all recognize is that there is a public resistance to partisan politics. And I'm not talking about necessarily with judicial seats, but I mean overall. We look at the numbers of approval for our senators and our Congress folks in DC, and it's in the tank because of the partisan bickering that we constantly see. In all of our cities and even in our state legislature, we see the angst that's created when our partisan politicians argue over philosophy and don't engage with issues that are impactful to the people first, and partisanship second. And what that results in is a real sick feeling in the populace over the idea of partisanship. So when we try to move forward and have the judges have partisan labels, as this will have for Supreme Court and Court of Appeals positions, not on municipal and county courts, I think that the potential is for a greater resistance to actually cast a ballot for a judicial office than there is right now. And we know there is a significant undervote, as Patrick showed in his slides, and as I can attest to you on many occasions, the drop off from mayor to city council to prosecutor to judge in all of the 6 races that I've been involved in. Sometimes it's as much as 30% an undervote of those who don't cast a ballot for those who are running for judge. I actually think with the party labels and the resistance that the populace has to it, it would actually be greater. But there's also an idea in the negative of the perception of the obligation to the parties that individuals have. We expect our senators to be beholden to a particular political philosophy. We expect our city council members to be beholden to particular political positions. We expect our judges to be fiercely independent and not beholden to particular political philosophies as they as we execute our duties as judges. The Constitution is the same 26 letters, no matter who's reading it. And you would expect that a judge is going to interpret it in a way that is most advantageous for the ideals that that Constitution stands for. The idea of political labels kind of runs contrary to that belief. And the money that is needed in these races when they're lined up to political parties, again, has the perception that that person will, in their decisions, in their hiring decisions, in their interpretation of the law, be beholden to the particular political philosophy of the party label that they're running under. That's a practical problem with the idea of these labels. And then we distinguish and say, well, it's not going to be for all judges. It's just going to be for the judges on the Supreme Court and the Court of Appeals. And I appreciate Justice Pfeiffer's insight into why that may be the case. What we've seen in the most recent elections statewide is there's been universal, well, not universal, there has been almost unanimous elected offices who are Republican, from governor to secretary of state on down. So there has to be a perception by someone who's looking to pass this law that that would be the same if the labels were affixed to the Supreme Court and the Court of Appeals races. But I think Justice Pfeiffer has a good point. And in Hamilton County, we're one of those rare counties when it comes to the Court of Appeals that is a single county Court of Appeals. Franklin County is also a single county Court of Appeals. Cuyahoga County, 8th District. There's only about 3 or 4 across the state. The others are encompassed in the other 80 counties. So there's some counties where a person who's running for the Court of Appeals is almost running a statewide race because they have 15 counties they have to run in at the same time. Well, in those larger counties, like Hamilton County and Franklin County and Cuyahoga County, our counties are decidedly democratically centered. Even in almost recent countywide election, almost every Democratic candidate running for judge was successful. There were about 2 or 3 exceptions out of 10. I suspect the same is true in Cuyahoga and the same is true in Franklin County, I suppose. If there are party labels in Hamilton County on the Court of Appeals, I can almost guarantee you that the Court of Appeals in the next election will almost be decidedly 100% Democrat. And it's interesting that Justice Pfeifer said they're doing it because they can and because there's fear about losing an election. And Justice Brennan, it's great to see you again. The fear or the concern about upcoming elections, and actually Justice Fisher, who is from Hamilton County, as well as Justice DeWine, this was actually a federal lawsuit about 10 years ago. A local judge here, who's now retired, who had been seated on the municipal court and then went on to common pleas, filed a lawsuit in federal court to have the party labels to be able to be added to judicial races and all judicial races. The lawsuit was unsuccessful, but it started opening the door for this conversation in a greater way. She actually is a Democrat who was able to win countywide elections in a time when Republicans were winning all of the races in Hamilton County. Her position was it would be helpful to her and helpful to Democratic running judges if they were able to have a D by their names. I think 10 years ago, it probably would have had the opposite impact. But today, again, in the larger counties, having a D by your name would almost seal the fate of the election just because of the numbers and the way that our counties are set up. So I just offer those. Of course, we have to balance those, and I can't wait to get to the questions. But we have to counter that with the idea that the truth is no one wins judicial races without party support. I just told you a moment ago, and I'd love to see the instances where an independent or someone who is not endorsed by a party has won a contested election. We have to recognize that as a truth. The second truth is, and this sounds harsh, we generally have an uninformed electorate. Not a dumb electorate, not an ignorant electorate, but an uninformed electorate. And so if we have an uninformed electorate, it makes it more likely that they're going to follow the course of being led by those who they otherwise affiliate with in their party affiliations. That's just the truth of it. It's a point of advocacy, in my opinion, for nonpartisan merit selection for our judicial seats instead of elections. Let's get folks who have demonstrated the experience of the position or their practice to get into these seats and make decisions in a nonpartisan, independent way without the stain of partisan labels guiding them in their races or in their appointments or in their decision-making processes. And I'll just add before I end, I have a kind of unique perspective on this, not only having run countywide and statewide and countywide and statewide, but I'm also a second-generation judge. My father was on the Indiana Supreme Court for 19 years and on the Court of Appeals for 9 years before that. And Indiana is one of those states where there is merit selection and then a retention vote after 7 years, where you can't actually run, but your name goes on the ballot. Like 95% of people have to say they don't want you anymore. But they don't have partisanship in their selections or in their retention votes. They also don't have to worry about the raising of the money. They don't have to worry about the conflicts of interest that, they don't have to worry about the conflict of interest that inevitably come along with that. And in one of my races, my father, when I was running for Supreme Court, he said, better you than me, because I don't have to run across the state and raise money. So good luck to you, and see you at Thanksgiving dinner. So anyway, just a different perspective from a practical position with regard to this proposed bill. And again, thank you all for having me here. I can't wait to answer questions.
Thank you, Judge Rucker. Melekte, you're up next.
Excellent. Thank you, Ohio Voice and the Ohio Fair Courts Alliance for welcoming me into this conversation. I'm empowered to see intersections of various progressive communities thinking deeply about these issues. As similar to what my colleagues lifted on this panel, the ACLU of Ohio firmly opposes Senate Bill 80 and House Bill 149. These are bills that would require party affiliation for only certain judicial candidates on the general election ballot. So as we talked about, we all agree that the cornerstone of a healthy democracy is an informed voter. I highly encourage ongoing electoral research into candidates, including looking at their party affiliation, including looking at policies that they've potentially talked highly about in the past. And however, requiring labels on certain judiciary races can potentially compromise the integrity of the judiciary and harm the everyday Ohioan. So as an organizing strategist at the ACLU, my role is to form coalitions, mobilize constituents, and change cultural narratives around pretrial and criminal legal reform. This includes facilitating conversations between everyday Ohioans and stakeholders like judges, county commissioners, prosecutors, people within the criminal legal space. And I know that just because a judge is a Democrat doesn't mean that we align on bail reform policies like adopting a broad presumption of release, assigning least restrictive conditions, or procedural safeguards to ensure a defendant doesn't languish in pretrial detention. This is especially true in Cleveland, in Cuyahoga County's jail, where in 2017, the Pretrial Justice Institute found that felony defendants who couldn't afford cash bail spent on average 102 days in pretrial detention, about 3 months in pretrial detention. And while Cuyahoga County has made some strides on the pretrial reform front, this is a predominantly Democratic municipal and common pleas bench. So again, this reflects a lot of trends that the ACLU of Ohio has been tracking for years on the Ohio General Assembly side. We know that legislators on both sides of the aisle continue to introduce bills that create more crimes, expand the scope of existing crime, and harshen criminal penalties. So our system of mass incarceration, both Democrats and Republicans have a hand in building and fortifying the carceral state, and they also should have a hand in dismantling it, since that is the will of the public, that is the constitutionally sound policies we should be abiding to at this point. And so I really want to uplift this point that a Democratic judge doesn't necessarily mean that they align around fundamental core tenets of good pretrial policy. So just want to uplift that point and really reiterate that within my perspective and my vantage point organizing around these issues. So again, around public perception, we need to ensure that these judicial races are viewed as fair, impartial, free from that taint of partisanship. And judges, as we know, are not beholden to political parties. And our legislators, as we know in Columbus, are passing laws that don't reflect the values or the will of the people. And we're in an ongoing struggle right now in the courts, as well as in the State House, to ensure that our policies match what that will and temperament of the public is. And so I'm excited to join mostly judicial and legal colleagues in this effort, but we need to hold our judges accountable through different ways. So making sure that our community activists, our organizers are telling judges what are the most constitutionally sound policies that they should consider, getting them and exposing them to different people in the community who've been harmed by policies around mass incarceration in particular, and building ongoing allyships and relationships with members of the judiciary, so we're not relying on partisan labels and we're not relying on partisan politics when making those decisions and making those judicial races meaningful for the public. And so I'm excited for questions and to continue engaging in this work.
Thank you, Melekte. That was really insightful. Justice Briner, I know you're not formally on the panel, but did you want to give any brief remarks or any comments to the group?
Well, I see, I took a look at who was attending here, and I see folks who worked on my election last year, and I'm grateful for the work that they did, because I have really valued the work that I've been able to do just in the going on 4 months that I've been on the court. And while some states would say, and some speakers would say, it's terrible that Ohio elects its judges, there are advantages to that, because throughout the election process, whether it was for Common Pleas Court or the Court of Appeals or the Ohio Supreme Court, I got to know firsthand the people of the state of Ohio. And that is so valuable to making good, fair, wise, well-reasoned decisions that take into account, the broadened experiences that you get from a campaign. Thank you so much for doing this tonight. And I'm just so really amazed at the thoughtful interest that I see just among the people who are attending here tonight. It means a lot for our judicial system in Ohio. So, and it's always good to see Paul Pfeifer.
Wonderful, thank you.
Fun too.
Okay, Jessica, you've been monitoring the chat. I think people are excited and ready to ask some questions. What should we do first?
They are, absolutely. So let's see. I'm going to pose a general question for our panelists. Anyone can jump in and answer. What can be done to improve public confidence in our judicial system?
Well, I know nobody else is speaking up. I think it's an everyday challenge. It's really dependent on the judges, and they work at this, and we encourage that to interact with their communities, whether it's a part-time county court judge at the bottom of the judicial food chain, or a Supreme Court justice. I think it's extremely important for outreach. Some judges, I did a column when I was on the Supreme Court that talked about cases that were decided and other subjects, and so anything that judges can do. Some of them go to high schools or grade schools, and those kinds of community outreach, speaking at service clubs, all of those things are important. And then where it gets more challenging is, and I addressed this with the judges a lot during the COVID situation. People were, when we had the lockdown, people were afraid for a while. Even I thought we might be headed for a depression, an awful depression. And I kept encouraging the judges to be visible and outspoken, because they occupy the central geography in your town, the courthouse. It's fundamental. It's the local symbol of our democracy, and the ongoing carrying out of the laws of our state, our Constitution. And so I think judges just need to work at being more visible, not from a standpoint of appearing to be campaigning constantly, but just from a standpoint of being visible. And as so many of our judges do a lot of various volunteer efforts, and I think it's just important to encourage as much of that as possible. I'll yield to others.
Yeah, I'd love to jump in and just reiterate Mr. Pfeifer's point about outreach. I think it should extend beyond outreach into allyship, into relationship building. because for the average Ohioan, you don't see your common pleas or municipal judge until every couple years when people need to campaign and they need to make sure that they're getting a certain number of voters in their jurisdiction. So this needs to move beyond outreach, beyond campaigning, not pandering to communities, but being in service to the community. That means having regular conversations with communities who are most deeply affected by mass incarceration. Who is being sentenced in that community? Are there groups that represent or move in the political ecosystem from that community? It's being exposed to different stories of people who go through a criminal legal system and could potentially provide a perspective to a judge that they've never heard before, or potentially make court processing observations that can potentially improve how the court actually runs. And this also goes into referring to the community when a judge, let's say, for example, feels hesitant about, adopting more, unsecured bonds for low-level offenses, as an example. If they are in contact, if she's in contact with a community group that's in support of bail reform, and she knows, there's a public will to try this policy, to pilot some of these policies. I know that there are people in the community that are deeply affected by pretrial detention. I know that this is a constitutionally sound policy. Other judges from other states all across the country, legal scholars, our own Ohio Supreme Court are in support of some of these bail reform and pretrial reform policies. So again, I think it extends beyond outreach into relationship building, into enduring relationships and conversations that can truly build and change culture. We know that the criminal legal system moves incredibly slow, so those meaningful and urgent conversations between community members and judges have the potential to expedite some of these changes that we all desperately want to see. And also, I think another aspect of this conversation that's not being lifted as much is how do we hold our state legislature accountable, how do we hold judges accountable, and how do we maintain the impartiality of the judicial branch as a whole. And so I want us to be thinking about these three questions simultaneously, because I think there are similar answers and more nuanced conversations that we can be having about more robust relationship between the judiciary and the people that they serve.
So I just have a few quick points. I certainly agree with what was just said. But one thing at the Brennan Center that we also advocate for, that we also think is vital for public confidence in the courts, is just ensuring that our courts are diverse and they reflect the communities that they serve. And in terms of diversity, we don't just mean in terms of race, ethnicity, or gender, but we also mean professional diversity. We recently put out an update to our report that looked at diversity on state Supreme Courts, and we found that there is just a dearth of former public defenders or legal aid attorneys on our state high courts. So in addition to advocating for more diversity, there are also reforms that would limit the influence of money in judicial elections, such as public financing of judicial elections, or stronger recusal rules, meaning rules that require judges to step aside from hearing cases involving parties that contributed money to their campaigns. Those are also reforms that could be adopted to increase public confidence in the judiciary.
Judge
To
Rucker,
avoid
do you have
duplication, I'll just
any?
say I yield and agree.
Okay. So, Patrick, I'm actually going to throw this one to you. Have there been any national or other sort of analysis or polling that speaks to the impact of nonpartisan judicial races on public confidence in the judiciary?
So I'm certain there must be some polling. I know that there are tons of studies that look at this issue. And like we've heard all day, all night, there are pros and cons. But one con is that when judges appear with party labels, they get tied with that political party. And when the public views judges as being beholden to one of the two major political parties, That does no favor in terms of public confidence.
Thank you. And Patrick put a link in the chat here on the Brennan Center's most recent diversity report, if you guys want to go ahead and take a look at that. I have a question for Justice Pfeifer and Judge Rucker. How much influence, if any, did politics have when you served on the Ohio Supreme Court and the Hamilton County Court? And what do you feel are major areas of the court system in Ohio that need the most reform?
Well, in terms of partisan politics, I was on the Supreme Court for 24 years.
Wow.
There's only one case, and that comes around every decade, that is really has big partisan overtones, and that's reapportionment, or the whether or not the redrawing of boundaries, legislative boundaries, conforms to the constitutional mandate. The last time that came around, it was a court that was 6-1 Republican. It was a Republican map. It was found to be constitutional 4-3. I dissented. Chief Justice O'Connor is a Republican, dissented, and Yvette Hickey Brown wrote a dissent. For me, the dissent was easy. One of the constitutional mandates is to keep the boundaries of legislative districts as compact and as and to wherever possible keep counties, townships, that kind of thing, all in one piece. And it was clear that that mandate was totally ignored. So that's a case that is always going to have political overtones, and the political parties expect that the folks from their political party on the court are going to stand with where they are on the question of constitutionality or the lack thereof of that issue. Other than that, no. I mean, there's certainly cases in which a Republican governor, school funding was regarded as the case of the century while I was there. A Republican-dominated court found it unconstitutional 3 or 4 times. I lost track of it. A combination of Republican justices, myself and Justice Douglas, together with Democrat justices Resnick and Sweeney, found the system unconstitutional. That was certainly, those were not happy days for the Republican governors or Republican legislators, but that would be an example of where party politics had nothing to do with outcome and shouldn't. And that would, that would be my experience over my 24 years on the Supreme Court. It's just not present. Now I did not mention what Judge Rucker pointed out, and that's a criticism of Ohio's system. They say, oh, well, Ohio's different than anybody else because you first have to run in a partisan primary, and then after the primary is over, and so they're saying, well, that's sort of a myth that partisan politics is involved. Our Chief Justice O'Connor has advocated eliminating that altogether and just having a free-for-all in the primary. And that's one way to do it. That's not going to happen. She advocated that. And when she first advocated, I remember Justice O'Donnell came to me and said, "Oh, Paul, we've got to go over and tell the legislature this is a bad idea." And I said, "Don't worry about it, Terry. She'll get a bunch of editorials saying it's a great idea, and neither political party is going to be for that, so nothing will happen." And that's exactly what happened. And I don't think our system's all that bad. I think it's incumbent on the two political parties to help select the best possible person representing their party, whether it's for county court judge or municipal judge, common pleas judge, Court of Appeals, or the Supreme Court. I think that's an obligation that the parties should shoulder. In some places, they shoulder it well. I recall when we tried to get a reaction from our judges to this present legislation, one judge in Cuyahoga County said, if you do this and bring it on down to the common pleas level, the ward captains are going to pick our judges, and it would be a terrible thing. And I mean, this was a Democrat judge. These were all anonymous, so I don't know who said that. But they said if you take it down to the trial level, the way the selections are going to be made in counties that are overwhelmingly Democrat or overwhelmingly Republican could be pretty ugly. So I think our system, as it exists, isn't all bad. Certainly at the Supreme Court level, the two political parties put a lot of effort into screening and trying to figure out who they could put forward that is not only well qualified, but has the best chance of winning. And that's so I think they've provide a valuable role, and as Fanon indicated, then for those for which party label makes a difference, they can look at the slate card. The parties get the slate card out to every voter. They also have in some of the urban areas, they have workers out on election day, standing out beyond the flag, standing out to slate cards. So those for whom party affiliation matters, it's available to them, and I see nothing wrong with that. Judge Rucker.
So you asked whether during my time on the bench, politics played a role.
Yeah,
I will say, well, I can say for me, no. I mean, there are 14 municipal court judges and about 15 common pleas judges in Hamilton County. And for me personally, no politics, no one ever called me from a party and said, hey, I need you to rule in this particular way. That would be federally illegal anyway, so I'm glad nobody did that. I don't play those type of games. It was never that blatant. But let me tell you how partisan politics played a role in the court. As I just said, we have 14 judges on the court that I sat on. We make, as a collective, decisions on hiring. We make decisions on court rules. We make decisions on whether or not we're going to change the way that our juries are selected and diversify the jury pool. As a collective, we meet once a month. We now twice a month, once every 2 months. It used to be once a month. And we, as a collective, by majority vote, make the decisions about who gets these jobs of probation officer and chief probation officer and where the money is allocated to. It's strictly, unfortunately, a partisan vote for about 80% of the decisions that are made. And so that's where politics played the biggest role with me as a judge. It was in the decisions about how the court was going to operate. And I've been in leadership in a lot of different organizations and groups, and I always say there's a meeting before the meeting. Of course there's a meeting before the meeting because you got an agenda. And if there's an agenda, that means there was a meeting before the meeting where somebody established the agenda. So by the time we would get to our meetings with all of the court, with all the judges, there had already been a decision made about, number one, what was going on the agenda, and really what direction whatever issue was up was going to go, because they had the majority. And our input was really more academic than it was substantive. And so that's where politics played the biggest role for me as a judge during the time I was on the bench. Now, certainly there were things that would happen and certain big cases would come before the court, and there was kind of a uniformity of decisions from one side of the aisle versus the other side when many of the different judges had the cases. We actually have that right now with some big cases that happened after the riots and the disturbances and protests last summer, where many of the protesters filed motions to dismiss their cases saying, all right, we're going to challenge the legitimacy of these arrests. And, you know, almost by party, one group got their cases dismissed, and almost by party, the other cases were not dismissed. Now, people can say, well, it has nothing to do with politics. People were making decisions based on how they interpreted the law. That's fine. But from a practical standpoint, the eyes of the people, those who are impacted by these decisions, certainly can perceive that politics has some role. Even if it didn't, it certainly looks that way. So that's my answer about politics and the role it played in decision making.
Thank you so much.
Thank you. Thank you. I know we have a few judges that are also have joined us that we haven't yet heard from. Judge Trapp, did you want to speak to any of this?
Sure. I have a rather long and unique and varied perspective on judicial elections, because I started out in judicial election land as a law student circulating petitions in whenever, when the State Bar Association wanted to pass merit selection. And by the end, there's nothing like standing in front of Uncle Bill's, which is the Cleveland equivalent of Target, and talking to normal people about judicial elections to change your mind. And that's when I realized that as the State Bar Association, which I had the honor to lead as president, the State Bar Association learned a very hard lesson after trying to do merit selection twice in Ohio. And that is that all you have to tell normal people is they're taking away your right to vote for judges. And it's a non-starter. So, you know, that ship has sailed. I see some of the questions in the comments about going to merit selection. And the one thing I will commend all of you to do is please go to the Brennan Center's website. I have relied on the information and the studies from the Brennan Center since I was State Bar Association president 20 years ago. Since I ran statewide, as Judge Rucker did, I ran statewide unsuccessfully for Supreme Court, but I ran, and I've served now 2 terms in a 5-county district in Northeast Ohio in the Court of Appeals. And what I realized from reading from the studies from the Brennan Center and from talking to my colleagues, both Bar Association colleagues from around the country and at the American Bar Association and my colleagues on the bench, is that there really is no perfect system. Some of my colleagues, for instance, out in Iowa, there was one very hot button issue that Supreme Court decided, and an out-of-state one theme group that was on the losing side of that issue targeted those justices, brought in millions of dollars into that race, and wiped out sitting justices on a court because of one vote. So, you know, that merit selection isn't the panacea. I happen to believe, as Justice Pfeifer does, that the grand compromise that occurred back in the early 1900s between having the legislature in the past pick the judges, and then the party bosses at conventions pick the judges. The grand compromise with the nonpartisan, I think it was in 1911 or something, that the great compromise was that judicial candidates would go through a vetting within the party primary system. They would lose their party affiliation on the ballot and run in a nonpartisan general. while that may be intellectually dishonest and very difficult to explain to voters that are interested in judicial races why that happens, it was a compromise that frankly has worked. My experience both on and off the bench, and I was a litigator, litigating statewide. I was in courts, big and small, all over the state for years before I went on the bench. And it really didn't matter the party affiliation of the judge that I appeared in front of. It really didn't. I think for the most part, we have a good bench. That compromise has worked. I've lost elections that I knew I lost because I didn't have a party affiliation. I've won elections where I know that I won because I didn't have a party affiliation. My fear is, and what I pose to all of you, especially the groups that are convening this discussion, is what are we going to do about it? I mean, the Senate has already passed, and I think Justice Pfeifer has his finger on the pulse down there. Frankly, I think the only way that this is going to go off the rails is if there is a push to actually require the party designation to be from top to bottom. And I don't think that's going to happen because, and again, I'm speaking, this is Mary Jane Trapp, not Judge Mary Jane Trapp talking. But if you get to the party, you get to the people in the General Assembly that have close relationships with their common pleas court judges or with their municipal court judges or their county court judges, they're going to talk to them at, Rotary. They're going to talk to them on the golf course. They're going to talk to them at any events. They're going to say, hey, what are you doing to me? What are you doing to me? I'm going to lose my seat. Or I want to run for the Court of Appeals. I happen to be an African-American man who wants to run for the Court of Appeals in Northeast Ohio, and I'm a Republican. I don't have a snowball's chance in hell of winning. So if you force that issue, I think politically you'll have a better shot. And I'll leave with this. There was a Sixth Circuit case, I believe, and maybe Justice Bruner knows about it a little better than I, but it was AFSCME had brought a case, and the problem with is there's an equal protection argument to be made on a constitutional level. And the Sixth Circuit has already recognized that if you have party affiliations for just some judges, but not all, it's constitutionally infirm. So maybe this passes and maybe it comes into effect and affects a Supreme Court race in 22. But if I were still in the litigation betting mode, I would think that there's some constitutional challenges on a federal court basis. So I'll leave it with that. But thank you for doing this. I mean, at least we're talking about it and not just laying down and allowing this to happen. Again, go to the Brennan Center website. It's a great educational site.
Thank you so much. Piggybacking off of that, I have received a very pointed question. How is a judge able to say the party has no place in their politics after using the funding from a party to run and be elected? The appearance of being beholden is inescapable. How does one combat that potential impropriety and substantiate their veracity?
Well, I'll address part of that. I don't think the political parties contribute much at all. It certainly never happened to me. And I don't think it really does. The judicial candidates are pretty much on their own to raise money. And again, the rules do another thing to try and extend the perception of impartiality. Judicial candidates can't even do the ask. They have to have others do the ask for them. So you can look at it. I mean, when you get to Supreme Court races, there are certain business interests and certain labor interests and plaintiffs' lawyers that tend to go in one direction or another. So there may be a concentration of specific interests that focus in one direction or another. I was fortunate enough not to be opposed twice in elections of the Supreme Court, and it was in no small part because I was a bit unpredictable. So none of those interests knew where I might fall out on any particular case, and so they decided to let me alone. And in the case of the plaintiffs' lawyers, for example, they decided we want to concentrate our financial interests on the other candidate because we don't dislike the way you decide cases that much. I mean, it was just that's simple. So I think it's other than providing slate cards and that kind of thing, they do that to assist the. In fact, in the Senate, the president of the Court of Appeals Judges Association came in and testified, and she was quizzed, the chairman, and they only knew a day ahead that she was going to be there. The chairman looked up her contributions and saw that she had written checks to the Democrat Party of Trumbull County and of Ashtabula County. And so they were hitting her up on that and saying, well, doesn't that indicate you're partisan? She said, no, that was my fair share of the cost of the slate cards. So quite the contrary to, and that was Judge Rice's report on how that all works. And instead of the party giving her money, she was giving the party money to help bear the expense of a slate card. So I think the notion that political parties play a big role in financing judicial elections it's probably not true. I suppose it happens someplace, but it's rare.
That's really good to know. Justice Bruner, thank you for chatting me there. Yes, please give us your experience in 2020.
I've been running for political office or for judge over 20 years. And 2020, when I was recruited by David Pepper, he basically said, all we want is for you to be fair. He said, we have redistricting and reapportionment coming up. This is the first time we'll be using a new formula. We know that if you're there, that the decisions will be fair. So I didn't get that kind of pressure. And I did, for the first time ever, receive substantial time, effort, funding from the Ohio Democratic Party. I have always run for judge thinking I'm on my own and whatever I get from the party is just icing on the cake, but I it's not my bread and butter. I think the party, I know in the Franklin County Democratic Party, there's a team of pretty responsible people, including attorneys, who really do look for the quality of the candidate when they are vetting candidates. When I first ran for judge in Franklin County was not primarily my party. So but once I won, once other people like Rick Fry won, then a lot of people flocked and said, hey, I want to be a judge. And the parties had to really kind of tell people, well, we've got enough, you need to wait. And they really have vetted people for the quality of their work, for their independence, and you know, because they want judges who will make their supporters proud, and that means being independent. And I think that people expect judges to be independent, and I think the party expects judges to be independent. If I go back in time and in history to Summit County, the Supreme Court just decided a case where we issued a writ against the Secretary of State for not appointing a Republican to the Board of Elections based on factors relating to how competent that person was. I was in the same position when I was Secretary of State back in 2008, 2009. And one of the allegations against the county party chair, who's now deceased, was that he tried to push his judges around, and judges wrote and gave affidavits. And interestingly, when I would not appoint him to the Board of Elections, I was upheld by the Ohio Supreme Court because I had good reason to not do it. I do want to point out too that state political parties and county political parties can only give their money to judicial candidates' campaign funds through what's called a judicial campaign fund. Now, what's tricky about that is that there's also a state candidate fund, because there are a different set of rules for funding for candidates running for state rep or statewide office. But in the revised code scheme, the contribution limit to the judicial fund and to the state candidate fund are shared. So, you know, I think what you're likely to see in years where state candidates are on the ballot for the executive offices, like upcoming in 2022, some donors who would normally give to judicial races are more interested in the state races, and so you'll probably see less funding from the parties in the years where there are statewide candidates on the ballot. So, I mean, I'm bringing this up because all of these things play into you know, how folks get elected to office. And I do agree with what Judge Trapp said. And I think Judge Beatty Blunt's also on the call tonight too. But I do agree with Judge Trapp and Justice Pfeifer and Judge Rucker that, you know, when you're running for a judicial race, you have to pretty much put on the thinking that you're on your own, and if you don't do this, somebody's not going to step in and do it for you.
Thank you so much.
Judge Laurel Beatty Blunt, did you want to chime in? Have any comments you wanted to share with the group?
I am COVID parenting. Let me step out, or you're going to hear 4 kids under 8.
Oh boy.
First of all, thank you so much for having this. To Judge Rucker's point, I agree. I have seen party line decisions as far as court administration is concerned, most recently concerning COVID. Those you have seen Republican and Democrat judges across the state feeling very differently about what to do as far as jurors and courts being open and things like that, and those votes falling along party lines. I have run for election 3 times and tried for a federal appointment once. And if I had, both sides have pluses and minuses, but my personal preference would be election, because the appointment process felt very backroom. I did not feel like I knew what was going on. And when you are running for election, you know, at least you have some control. You know, you can work your butt off and cover the county and do what you need to do. And at least you feel like you had a part in becoming a judge. But I also think as far as political affiliation, and judges, you can't underestimate the courage that is required of us to do this job. Because even if you want to rule on party lines, if the law says you can't, you have to have the courage to rule against your party. And it is not easy. A lot of times also when you run for election and win and you're on the bench, you know, you've gone from being a player to being the referee. So you're also, it's not just, it's people that you've worked with in the party, you know, there's bonding over traumatic experiences, right? So you become friends over lit drops. So it takes a lot of courage. And so sometimes, because with judges, we don't want ideologues necessarily. We want people who will follow the law. And sometimes even the winners aren't happy in our job. So you have to have the courage to follow the law regardless of your party.
Thank you so much for that insight. Sorry for putting you on the spot.
Oh,
we really
it's okay.
appreciate it.
Like I said, it's so long as you understand COVID parenting, we're all good.
Yes.
I'm going back in.
We had a lot of questions about what voters and or the public could do, say in terms of HB 80 passing and Senate Bill 149. Melekte, as a community organizer and strategist, what can the public do to fight back? What can the public do, you know, to sort of make their voice be heard? Can you speak a little bit about that, please?
I would absolutely love to. So
Thank
I
you.
would encourage everybody to join their ACLU action team. The action team is an organizing branch of the ACLU affiliate. We have, organizing hubs in Central Ohio, Southwest Ohio, Northeast Ohio, and we're building up constituent bases of people who can inform the judiciary of different policies, expose them to people who've been directly impacted by sentencing decisions, start that robust relationship between the judiciary and community members that they serve. So I am going to drop a link to the action team in the chat.
I got it for you.
Excellent. And for folks who are in Northeast Ohio, we're actually engaging on a judicial forum series where we're meeting all of the municipal and common pleas judges. We're talking about bail reform. We're teaching skills like testimony, writing, and training. So, if that bill potentially moves to a different committee, we have an informed electorate that can send 50, 60, 100, 200 pieces of testimony to the State House to begin forming that kind of mass mobilized defense that we need to stop bills like these. Thank you.
Thank you so much. Patrick, can you also speak about what voters or the public can do in regards to this bill or any others?
So I would say just more generally with regards to, the courts is, I think it's important for the general public just to pay attention to courts. I think often most people don't think about courts unless they're interacting with them, and they fail to, understand just how much impact courts can have on your day-to-day life, state courts in particular. Those are the courts that, hear the most civil cases and the most criminal trials. And so it's, very important to understand, what role courts play, and who the judges are, and so on.
Thank you so much. We had some great questions. We're sorry if we didn't get to all of them. I'm going to throw it back to Camille. We have some slides about how you can get involved.
Thanks, Jessica. So I think we can, since we're like right at time, what I'll do is I'll just send some follow-up email that has links to the resources that we have to get more information, things like judicial votes count and so on, so that you have like an action word that you can take to follow up on Senate Bill 80 that has all of the great links that all of our panelists shared. And know that we're going to be planning some future events. We're trying to do something around quarterly. So I'll also try to get a little poll from you guys about what topics you might want to hear from next. So I think we're ready to close out. Maybe just have a few final comments. I know we've talked to Patrick and Melekte. If Judge Rucker and Judge Pfeifer just want to leave us with some parting thoughts, I think we'll be ready to roll. Judge Rucker?
All right, I'll start. Thomas Jefferson is my favorite founding father. One of his quotes on the outside of the courthouse, it says, "Equal and exact justice to all, no matter state or persuasion, religious or political." He said that at his second inauguration in 1802, I believe. But that's what the goal is. It's equal and exact justice to all, regardless of all of those external factors, including political persuasion or political position, party affiliation or persuasion. So thank you all again for allowing me to be part of this, and look forward to connecting with you all in the future.
Justice Pfeifer?
Yeah, for those who are wanting, what can I do? It now moves to the House of Representatives. I think it's problematic, but it never hurts if you have connections, particularly if you have connections with leadership, to indicate your concern on this. But stay engaged and keeping the public understanding that the independence and a fair judiciary is an ongoing struggle. The challenges never end, and this is just one bump in the road as I see it. There are challenges to the notion of an independent judiciary, and they come along, who knows what the next case is going to blow up and be national attention or attention on Ohio, and the talking heads on TV will be trying to make some judge out to be grossly unfair. We hope that would be wrong, but they're, when judges make the tough calls, there are plenty of boo birds are willing to suggest that the motivations were less than pure. So anybody that can help out and speak up when those things happen are important to the ongoing effort to have the public have great confidence in an unbiased and fair and impartial judiciary, top to bottom. And great program.
Yes, thank you so much. Thank you to all of our panelists, and of course to our judges for coming and lending their perspectives. And thank you again to everyone who participated tonight. We'll send follow-up information, and we look forward to seeing you in a few months. All right, have a good night.
Thank you so much, everyone. We appreciate it.